Hello, everyone. I hope we are audible to you. Welcome once again to the 8th webinar of BHR course 2020. And we in this session are going to discuss access to remedy, choosing the right option. So as indicated by one of our presenters the other day, that without proper access to remedy, there is no actual justice. So on that note, I would very quickly introduce you to our presenters of the day. And I have with me Tara Van Ho, who is the lecturer and educational director of the postgraduate programs in the human rights at the University of Essex School of Law. And Tara is joined with ANIRUDHA Nagar, who is the co-director for Accountability Council's Communities Program. So much for, without any further ado, I would request both our presenters to please take us through their insightful presentations. I would request all the participants to keep sending in their questions, and the presenters will take a look at it during the session and will try to address as many questions as possible. Thank you. Over to you, Tara.
Thank you so much, Alina. Just to take everyone through what we're going to do, I'm going to lay out some of the foundations for remedies, as well as some of the expectations about what appropriate remedial processes are supposed to look like. And then I'm going to hand it over to Anirudh, who's going to tell you what it looks like in practice, particularly with regard to non-judicial remedies. And you'll see that there's a little bit of a disconnect there. Let's start with our first poll question. So Alina's going to launch this for us, but I really want to get a sense as to what you think remedies are supposed to be doing, or why it is that people seek them.
Hi, so the poll question, the first question that we have on our screen is, what is the primary motivation for people to seek remediation? Your options are to get money, to be heard, to get harmful activity to stop, all of the above, or none of the above. Please feed in your votes and then we can see your results.
Okay, so that's quite interesting. A lot of you see that remedies can have a lot of different motivations behind them. Victims seeking remedies can have a lot of different motivation behind them. So to get money, to be heard, to stop the harmful conduct. And some of you think it's none of the above. So I'm going to be interested. I'm going to ask you, if you voted none of the above, if you can leave us a comment in the question section and tell us what you think remedies are about, so we can potentially address those. The reason that I wanted to start with why people do remedies or seek remedies is because ultimately remedies are about the victim. The entire remedial process is about the victim seeking to have their rights realized and to have them respected moving forward. When I talk about victims, this is a controversial term in human rights. I know Surya Deva prefers rights holders. I usually prefer rights holders too, but when I'm talking about remedies, I always use the term victim because first, that's generally what we talk about within public international law. But second, it's really about recognizing that this is somebody who has been disadvantaged and their rights not realized. And the effort is to return them to a position that they would have been but for the violation. Victims can be either direct or indirect, meaning if you are tortured, you are a direct victim, but your families may suffer some of the repercussions of that. So if we think about business and human rights and the Rana Plaza disaster, the people who were in the factory when it collapsed are the direct victims, but their families are often the indirect victims because their family life has been disrupted, their emotional well-being has been disrupted, and so has their financial stability. Oftentimes this will impact other rights too, like the right to housing. So it's important to recognize that victims are both direct and indirect. They can be individuals or they can be communities, depending on what happens in the particular case. Within business and human rights, most cases involve actually community harm. Most of our dominant cases, it's issues in which either there hasn't been adequate wages paid to people working in a factory, and then the people who work in that factory are defined as the community. Sometimes it involves taking of land from whole communities. Sometimes this is an indigenous community, so the term community there is really with a capital C or a big C. But sometimes it's also land taking within a smaller community that doesn't necessarily have indigenous protections. We need to really understand that, because there's how you seek remedies, who you seek remedies with will often be informed by who else has been victimized. All victims have a right to adequate remedies. These should be adequate, meaning that they're capable of redressing the harm. They should be effective, meaning that they actually are followed through on. They should be prompt, meaning that you shouldn't have to wait a long time to access remedies. And they need to be appropriate, meaning that they're capable of restoring the victim to the position that she would have been in, but for the violation. The right to a remedy is a standalone right in international human rights law, but it's also an element of all other rights. You can't ask a state or a business to respect your human right unless you can also challenge them when they don't. And so remedies has that component to it, and it's embedded in all other human rights. Within that, to realize that the purpose of remedies, you need to have processes capable of acknowledging the wrongdoing and ordering substantive remedies. So you need to have a mechanism by which you can challenge the wrongdoing, and in which an independent body can say, first of all, this was wrong and it shouldn't have happened. And second of all, this is how we make it right. And the how we make it right is the substantive remedial portion of this. Substantive reparations need to be capable of compensating for the loss, and it needs to be capable of compensating for a variety of different types of losses. So, sorry, I'm going to stay on this page for a second. So when we talk about substantive remedies, victims should have satisfaction, meaning an acknowledgement of the wrongdoing, but they should also be entitled to rehabilitation if they've had any losses of either their physical or mental well-being, their economic stability, or their ability to perform their job, as well as social conditions. A lot of times we see within human rights violations that there becomes a social stigma on the victims for what happened to them. And sometimes that requires social rehabilitation. In addition to satisfaction and rehabilitation, you also need restitution, a restoring of what was taken. Sometimes this will mean that you release someone from prison. Sometimes it means that you provide them with their property back. That restitution is actually the primary substantive remedy under international law. It should be the first step before you look at anything else. You should also have guarantees of non-recurrence, which are changes to your policies or processes that are capable of ensuring that the harm that happened doesn't happen again. And then finally, there's compensation. And compensation is about providing a catch-all for the things that were lost that can't be addressed by the other forms of reparations. It includes monetary losses, but also sometimes moral harms or damages. So if you've had defamation, it will include the remedial substantive remedies will look along the lines of an apology publicly, also compensation for any moral harms that you've suffered. So when we're looking at remedies substantively, we're looking at that whole catch-all. That's why I wanted to know what you thought people were after, because oftentimes they're after a combination of those types of remedies. They want to be heard. They want an acknowledgement that there was a wrongdoing. They want to make sure it doesn't happen again. But they also need compensation to address for the harms they've suffered, or to help them retain their house, or to make sure that they can continue to eat and live appropriately. There isn't one reason that victims go forward for remedies. They often go for a variety of different reasons, but they go because they've suffered a wrongdoing and they need someone to make it right. Remedies are fundamentally about the distribution of responsibility when something goes wrong. Who actually is required to bear the burden of the losses that were suffered? Should it be on the victim who didn't perpetrate the wrongdoing, or should it be on those who were behind the violation itself? And we look at under what conditions do we change when remedies are owed, or who owes remedies. But fundamentally, it's about making sure that that victim is restored to the position that they would have been in but for the violation. I'm sorry, I can hear my police sirens in the back. That doesn't usually happen in this area, so I hope that you're not hearing it, or that if you are, that it's not too loud. With victims' remedies, there are attendant state responsibilities or obligations. So states must ensure that they have adequate judicial remedies capable of hearing complaints against the businesses as well as against the state. Oftentimes within business and human rights, what we have are cases that involve both state and business action. And you need a judicial process that's capable of hearing both of those types of complaints. States are also obligated to adopt measures, whether that's legislation or regulation, to ensure that they can do this and that they can reduce any barriers to remedies. By barriers to remedies, I'm talking about things like the accessibility of a remedial process. If it's a long distance and people can't get there easily, that's a barrier to a remedy. If it's really expensive, if you need trained legal counsel and that becomes inaccessible to people because of the expense, that's a barrier to your access to remedy. And states have an obligation to take action to make sure that they reduce those barriers. There's also a question within business and human rights as to whether or not they should adopt non-judicial mechanisms. By non-judicial mechanisms, we mean things that are set up either by the state or by the business that functions outside of the normal judicial system. So this will be things like arbitration or reconciliation tribunals. Within business and human rights, the guiding principle suggests that states should do this, and that they should do this because it will help alleviate some of the tension, and it will reduce the access to barriers of remedies, to the substantive remedies, by allowing victims to seek an inexpensive alternative to judicial remedies. That's not yet an obligation under international law. It's a may, it's a should, but it's not a must. So states should consider this. They may adopt it. They are not yet obligated to do so. But if they don't have the non-judicial remedial mechanisms, then they need to really reevaluate what barriers are preventing people from getting access to legitimate remediation and reparations for issues that for cases that they've had and for issues that they've had with the businesses. When it comes to where a business or a state has its responsibility, it very firmly has a responsibility to make sure its remedy systems are accessible for harms that take place on its territory or under its jurisdiction. Now, there's a question about what under its jurisdiction means. Within international human rights law, two of the prominent UN bodies that decide on what states' obligations are have suggested that states have an extraterritorial responsibility over their corporations acting abroad. This means that states are expected to make sure that their judicial remedy processes can be accessed by victims who are harmed by their businesses operating overseas. So if you're talking about Canada and there's a company operating in Peru, the Peruvians should be able to go to Canada. That's actually part of the foundational cases behind this decision. But for India, that means that if you have a company operating in, say, Ethiopia, the Indian government should provide remedial processes capable of redressing that harm that took place in Ethiopia. And ultimately, this is about increasing access to remedies. It's about ensuring that individuals who have been harmed have a venue that they can go to and that they trust and where they feel safe. This isn't yet a firm obligation. Even the two committees that have really recognized that this is something states should be doing haven't yet said that this is an obligation on states to provide remedies for their businesses operating abroad. But they come quite close to saying that. They make it clear that states should be taking responsibility for their businesses when they operate abroad, because if they're not, then they're creating entities or creating legal fictions, sending them out into the world without any accountability or repercussions. And it's that foundational understanding that says that actually the states have a responsibility to take accountability or provide accountability for their own corporations operating abroad. Many of the cases that have come up with regard to procedure I'm going to go back one slide. Many of the cases that have come up with regard to extraterritorial jurisdiction have been in the US or Europe. In Europe, any parent company can be sued, any company period, can be sued in the state in which they're registered or headquartered. In the United States, that's a much harder test. There's a lot more reasons why a case can't be heard in the United States, even against a US company. But many of our foundational cases have taken place either in Europe or in the US. We are, however, increasingly seeing cases being taken in other places, including Taiwan and Hong Kong. So, sorry, Thailand and Hong Kong. So we are seeing that this home state responsibility isn't just an issue of states and parent companies located in the global north abusing rights overseas, but it's actually a global issue, and we've seen an increasing number of south-south impacts. So states from the global, companies based in global south states impacting on the rights of people in other global south states, and looking at how do those states then work together to increase the remedial processes. Now, I've already talked a little bit about substantive reparations. I'm going to launch our second poll question now, or actually I'm going to ask Alina to do so because I don't have the capability. Okay, so
our second poll question, Tara, would you like to take us through the second poll question?
Sure.
Sorry.
So the second poll question is, due to their economic nature, businesses should only be required to pay compensation. So they shouldn't be required to do any of those other things I talked about. Select one of the following. Either I agree with that or I disagree with that. Okay, so 69% of you said you disagree and 31% said you agree. That's quite interesting. So this comes down to the question of who gets to decide what kinds of substantive reparations are required. And this has been an ongoing debate within business and human rights. Sorry, I'm gonna come back to this. Because a lot of times when it comes to non-judicial remedial systems set up by businesses, what you see is that they primarily focus on compensation. When businesses are looking at what they should be providing, they're willing to pay for somebody to, access furniture or to rebuild their house, but they're not necessarily willing to take the other steps. And most importantly, they're very rarely willing to admit responsibility for the past. This is because they're looking to avoid sort of establishing a pattern of misconduct. So if they deny responsibility but pay the compensation otherwise, then they're avoiding sort of an ongoing pattern or acknowledging that there's a pattern of responsibility and a pattern of abuses. So businesses are really often willing to provide compensation, but they're not necessarily willing to provide the other forms. And they often fall back on their economic nature in saying why they won't do it. This is really problematic for a lot of victims. When I've done work, and I've done work in places like Myanmar and Palestine and Colombia and Afghanistan, and when I've looked at what the victims are asking for, what they're often asking for is an acknowledgement of what happened and an apology from the company for what they've suffered. The compensation is oftentimes the last thing that they want. It's the thing that sort of mops up everything else. But what they're really looking for is a recognition that what happened shouldn't have occurred. And they're looking for sort of policies and processes to be reformed so that it doesn't continue to occur. Sometimes, particularly with Indigenous communities, they're also looking for restitution, a right to return to their land, and a right to continue and commence communal practices and religious practices that are associated with the land that they were on. When businesses are unwilling to engage in these kinds of remedies and reparations, it makes non-judicial remedial processes relatively ineffective. Oftentimes what you'll see is that businesses will have these policies and processes, but the community members and the victims don't really feel like they can use them appropriately. If they do, it's just, they feel like oftentimes it's a delaying tactic, something that means that they have to go through this process before they can actually access judicial remedies. And so there's oftentimes, if businesses are only willing to provide compensation, there's oftentimes a breakdown in terms of the expectations between community members and the business, and that can become a really confrontational issue and undermine many of the efforts to increase remedies for victims. Within the guiding principles, there's also some very clear statements about the procedural expectations for state and non-judicial mechanisms. Let me try that again, sorry. For state and non-state non-judicial grievance mechanisms. So again, as I said before, states can set up things like arbitration or reconciliation panels. Businesses can do the same, and the expectation within the guiding principles is that businesses will do this, that they will try to address the harms at an early stage so they don't become escalated into something that needs to go to a judicial mechanism. When setting these things up, both the state and businesses should make sure that they're legitimate, meaning that they're accountable and that they enable trust. There should be a process in which there's some level of independence, and that they're not underneath the businesses or the state's sort of thumb. They also need to be accessible. This means physically, financially, and culturally. If you're in a community where women aren't supposed to talk to men and all the judges and all the police officers and sorry, not police officers, but all the arbitrators are all men, you're going to have a really hard time getting women witnesses to be able to participate. And so there needs to be an accessible mechanism, and that needs to include not just the physical and financial elements, but also the culturally appropriate elements. They should also be predictable, meaning that there should be clear and known procedures. When the victim shows up to the process, they should know how to file a complaint and what will happen after that complaint is filed. They also need to be equitable, meaning that parties should have reasonable access to the information, advice, and expertise necessary to take the case forward and to make sure it comes to its logical conclusion. They should be transparent, meaning that there's sufficient information in the public domain that people understand how the cases are being decided and what's coming out of them. This is intended to build confidence in the mechanism, but it also meets the public's interest to know about how legitimate these entities are and whether or not they're actually meeting the expectations that the guiding principles set out for them. They need to be rights compatible, meaning that they need to be in line with international human rights law. This brings us back to the point that victims have a right to substantive remediation and reparations. So if a victim is not getting reparations, if they're only getting compensation, but they're not getting the other forms of reparations, there's a question about whether or not the mechanism itself can even be rights compatible. They should finally be a source of continuous learning, meaning that as the non-judicial grievance mechanisms come to decisions and reach decisions, they should be sent back to the company, and the company should be using this to assess and reframe their human rights due diligence, making sure that they are taking lessons learned from the cases that have come before them. At the operational level grievance mechanism, so these are things that are set up only by businesses and not by the states, they should also be based on engagement and dialogue, with affected stakeholders, meaning that community members should help construct grievance mechanisms that are appropriate for them. This is where you'll find that there will often be cultural requirements or expectations for a non-judicial grievance mechanism, and these should be informed, and there should be a negotiation or a conversation about what the mechanism will look like. Finally, they need to be appealable to judicial mechanisms. Again, there is a right to an adequate and effective remediation, and that right impacts on the state's obligations. And so ultimately, the obligation of the state is such that it needs to make sure that these mechanisms are operating appropriately, and the way in which you do that is to appeal to the judicial grievance mechanism. It's also noteworthy that sometimes businesses require, as part of their operational level grievance mechanisms, they require victims to waive a right to go to a judicial remedy. So you'll often see this in terms of arbitration clauses, which mandate that the parties will use arbitration rather than any other form of judicial and non-judicial grievance mechanism. Voluntary arbitration or opt-in arbitration clauses are perfectly aligned with the guiding principles, but mandatory arbitration clauses for non-commercial purposes, so anything impacting on actual human rights, those are really problematic because it means that you're limiting the right to adequate remediation and effective remediation by the victim. When it comes to judicial mechanisms, there are several significant hurdles. And I'm going to finish with I think, this slide or the next one. And then I'm going to turn it over to ANIRUDHA, who's going to talk about the non-judicial mechanisms. But within judicial mechanisms, some of the hurdles that we see are issues of discovery. Who has the information? Generally, the information about patterns of abuse or who's responsible for a violation, or what measures were taken to limit the likelihood of a violation occurring, that rests ultimately with the business. So then the question is, when is that business required to provide that information over to the claimants? This can be a really problematic issue because if the discovery processes in a state say that you can only do so after you have to have adequate evidence at this time in which you start a claim, or that you can only receive evidence if you know exactly what evidence you're looking for. That will often limit the ability of a victim to have access to the information necessary to take a case forward. So we often see issues of discovery limiting the ability of victims to pursue adequate remedies. And sometimes ultimately we find through other cases in other jurisdictions that when that information is disclosed, it's quite incriminating for the business. And had the victims in the first jurisdiction had access to that information, they would have likely received significant remediation. So we need to know when discovery happens, and states need to be evaluating their discovery rules in line with the UN guiding principles. There are also issues with statutes of limitations. There are questions about whether or not statutes of limitations are appropriate, how statute of limitations might limit the use of non-judicial mechanisms or efforts at negotiation and their utility. So we saw this with the Ali Enterprises factory fire in Pakistan. The victims agreed with the business, with a brand purchaser in Germany. They agreed that they would continue negotiations past the statute of limitations so that the victims wouldn't file the claim, and the business agreed that it would waive the claim, that it would waive the statute of limitations argument in defense. And they did this so that they could continue to try to reach an agreement amicably. The statute of limitations was quite short within Pakistan. It was a remnant from British colonialism. And they hadn't actually updated it to reflect modern statutes of limitations, which are often longer, particularly in personal injury cases like this. When it went to the German courts, while the company itself didn't raise the defense, their expert did, and their expert came forward and said that under Pakistani law, statute of limitations can't be waived. What that meant was that the German government was bound to apply Pakistani law in the case, and decided that it could, the German court, not the government, and it determined that it couldn't continue to hear the case. So they dismissed the case, and this allowed the business to decide for itself what remedies and reparations it was willing to provide. So we really need for states to be looking at their statutes of limitations and asking whether or not their rights compatible under international human rights law, and also whether or not the statute of limitations are so short that it undermines any effort to have issues of non-judicial grievance mechanisms. And then finally, there are issues of jurisdiction. Where can a business's impacts be heard? As I said before, a lot of cases went to the US and to the European states, where they were trying to attach responsibility either to the parent company or to a powerful purchaser, as in the Ali Enterprises case. Jurisdictional limits can be really restrictive, and it can be really difficult, even in the EU, where you can generally sue a business in their home state. Proving that the parent company has a responsibility, not just a subsidiary, can be a significant hurdle to getting access to judicial remedies elsewhere. This is important because if the harms are occurring in authoritarian states or states with weak judicial systems, then an access to a home state's judicial system can be an important benefit, and it can be an important means of realizing the access to remedy. It can often be the only way in which you can hold the corporation accountable. But if we have such limited jurisdictional bases, and if we're willing to kick out legitimate claims off of the issue of jurisdiction, Then there are issues about how we foreclosed access to how we foreclose access to remedies. And so states need to be looking at their jurisdictional roles to make sure that they also are rights compatible and facilitate adequate and appropriate remedies. As I said before, we're increasingly seeing a recognition of an obligation to regulate and provide remedies over a corporation when it operates abroad. This, however, while I've talked about the importance of increasing access to remedies, there are also a lot of problems with using home state jurisdiction. First of all, there are issues of financing. It's obviously much more expensive to take a case, if you're taking a case from Nigeria and to take it to the UK, just in terms of travel time to get there, let alone differences in the cost of attorney's fees between Nigeria and the UK. There are also issues of distance, and sometimes this results in issues of cultural understandings. So if people are viewing claims through their own cultural lens in the home state, they may not understand some of the nuances that are necessary within the host state or within the community that was victimized. This is particularly relevant if you're talking about indigenous communities, but not exclusively relevant to that. So you can oftentimes find issues whereby there's a cultural practice of serious significance in one country that just isn't understood, recognized, or appreciated in another country. Trying to compensate for those kinds of losses can be quite difficult for the judicial systems. And it's one of the reasons why home states litigation should really be deeply questioned and also only used in extreme circumstances or where it's the appropriate and adequate remedy system that the victims can trust. So with that, Anirudh, I'm turning this over to you.
Tara, thank you so much. Oh, yay, we have Anirudh. Wonderful.
So good to see you.
I'm so glad that I can. Am I audible? I hope that it's working.
You are
absolutely, audible. Absolutely.
And I'm going to actually turn my webcam off.
No, Tara, so I would ask both of you before moving into Anirudh's presentation, would you both like to take up a few questions from the questions window?
Sure, we can do that.
I see there are a lot of questions from Facebook Live session as well.
Okay.
So do you want me to read these questions to you, or would you have an access to it?
I don't have the Facebook Live up. Anirudh, do
no,
you?
No, you don't have to do the Facebook Live. In the questions window, you will see all the questions.
Okay. Okay, so there's some questions about PowerPoints, and I'm going to leave that to you, Alina.
Yeah, leave all that to me.
This is an interesting comment from Aishwara, sorry about that, where you say you believe that there's always a personal motive rather than a social motive in seeking remedies. And I think that that's probably often accurate. There are sometimes cases where people are seeking remedies because they're trying to seek a long-term social and sustainable change to how a company operates. But a lot of times it is about what have I lost and how do I make my life more normal. And I think in this period of COVID, we can all appreciate that, right? Like I would love for my life to look like it did 5 months ago. And when you've suffered a significant loss, as is often the case in these cases, then you're looking for something that works a little bit more. I will say that it is that mechanisms do need to be equal and they need to be adequate. So there should be processes appropriate for all sides to a case. So it's not an issue of just setting up something that's a grievance mechanism in which only the victims are heard, but it is making sure that in a grievance mechanism, the victims are actually heard, right? Because that's an important part. And the economic inequality that often exists between a corporation and a victim is often one of the causes for reducing access to remedies. It's one of the barriers. Companies like Shell, and I'm going to pick on Shell because I always do, companies like Shell have a great deal of wealth to spend on fighting claims against them, and they can spend it in Nigeria, they can spend it in the UK, they can spend it in the Netherlands, and it almost never really impacts their bottom line. Whereas for me, say, to take a case forward, even here in the UK, being paid in British pounds, it's actually going to significantly impact on my financial stability for the duration of the case. So what we're looking for with these grievance mechanisms isn't to give victims an automatic win, but rather to say that there needs to be equity, and we need to make sure they do have access to those processes. Tarun asked, sorry.
Yeah.
Yep.
So there's this question from our Facebook live session which says legal waivers are used in grievance mechanisms, but do you think it can be allowed in certain cases? Like, can there be exceptions?
So this is an ongoing debate within business and human rights, and the reality is no one has a firm answer. But if you're asking me what my opinion is on this, I think that there are times in which it can be appropriate. We've seen a lot of issues with sexual harassment cases in which it's not just a perpetrator who wants to keep the information quiet, but actually it's also the victim. They don't want to have their experience out in the public fora. They don't want to constantly be reading newspaper articles in which their depositions are being used. And it's a really tricky issue. So I think there are cases in which potentially you could find ways in which there's legitimate and adequate consent that allows for you to keep this confidential and keep it within an arbitration process without making it appealable. But I think that it really needs to be something where you're quite certain that both parties have free consent to do this, and they're not under the pressure either economically or socially under pressure to sign away their rights.
Right, and a very interesting question from Soumya Vajpayee. She says, how should responsibilities be divided between employers, employees, parent company, and subsidiaries for realization of full BHR goals?
Whew, that is a really tricky question. Anirudh, do you want to take that? Okay, he doesn't seem like he wants to take that, so I will try to answer this. The reality is all businesses within a supply chain or within a corporate group have their own independent responsibility to respect. So it is about making sure that each of them takes forward an appropriate human rights due diligence process and an appropriate remedial process. Who's going to actually know how to do that is actually going to change a little bit within contexts. So I do think that parent companies have a significant role to play in making sure that their subsidiaries have appropriate education, are knowledgeable about what they're doing, have appropriate processes in place. But when it comes to issues like whether or not a remedial process is culturally appropriate or not, the parent company is often not going to be particularly helpful with that. It's definitely going to be the subsidiary who has greater knowledge. And so there has to be a relationship there that's moving this forward appropriately. So they both need to take their responsibility. When it comes to employees, ultimately employees, and this has long been a case within the law, that often employees are considered to be the company. And so they don't have their own independent responsibility. They have the responsibility that comes with being employees of the company. And so it's on the managers and the directors to set appropriate policies and processes, and then on the employees to implement those appropriately. But if an employee is working within their normal job and within their business activities, the responsibility to remediate for any harms that they cause still falls back on the company. And whether that's the subsidiary or the parent company is going to be very specific to the case.
Okay, so one more question. Do you think these kind of cases will ever be considered as crimes against humanity and prosecuted by the international criminal law?
Whew, that is such a good question. So the reality is some cases, business and human rights cases are crimes against humanity, and that's unquestionable. So when you look at something like Lafarge, which paid ISIS or Daesh to be able to go back and forth within Daesh controlled territory, Lafarge was financing and funding crimes against humanity. So it has at least complicity or aiding and abetting responsibility. Now, the thing with the International Criminal Court is that it doesn't have jurisdiction over corporations or legal entities. It only has jurisdiction over natural persons. And so for a case like Lafarge, the issue is who within Lafarge made those decisions, and how much can you assign to them both the actus reus and the mens reus. So how much did they do the crime, and how much did they know that they were doing the crime or intend to do the crime. And that's going to be a really difficult thing. But yeah, some business and human rights cases are absolutely already crimes against humanity. And there's an increasing call for others, things like widespread pollution, to be considered a crime against humanity, or widespread land grabbing. Those are a little bit more difficult to show because you have to be able to show that it was a targeted attack against civilian populations. And sometimes it's just negligence or not caring enough. But if you can prove that targeted attack characteristic, you can absolutely show that some of these business and human rights cases are crimes against humanity.
Okay, thank you. Would you like to add anything, Anirudh? And there are these two actually conceptual questions. One is, what do you mean, if you could elaborate on social rehabilitation? And the other one is statutes of limitations. The question is by Tarun, and he is wanting you to elaborate a bit on these two concepts.
Okay, so by social rehabilitation, what I mean is measures that are aimed at allowing for the individual to function in society better. This will oftentimes involve some sort of education with the community. It can involve issues of reconciliation. Again, reconciliation commissions or panels. Sorry, you guys cut on me. Can you still hear me and see me?
Yes, yes. I've made
Great.
Anirudh the presenter, actually. He should be able
Okay,
to share his screen.
that's what happened. Great. Oftentimes this is about making sure that they have the capability to function in society. So it can be issues like talking with communities. The traditional example is sexual-based violence, where women are often excluded from their communities because they've been victimized by sexual-based violence. And within that, social rehabilitation will often involve teaching the women or working with the women so that they have the mental security and the feeling of connection to the community to go out in public again, so they don't feel that they have to stay home in order to be safe. And on the other side, it will be about teaching the society that the woman is not responsible for the violence that was perpetrated against her, and actually she should be part of the community, and that they need to welcome her back or create conditions in which she can fully participate in the society as a whole. It's a really tricky area of reparations law, and it can be really time consuming and also resource intense, because you really need trained people who can facilitate that kind of social rehabilitation. As for statutes of limitations, what statutes of limitations are limits to how long you can take a case forward. So if I am in a car accident today and I was the one who was driving, how long can the other person take this case against me? The law wants to provide some level of certainty so that at some point in your life or your existence, you can move forward. You know, if I was driving recklessly down the street, they know when the harm occurred, and the question is, how long after that harm should they be able to take a case against me? A year, 2 years makes sense, but if you're talking about 25 years, in 25 years, I'm not going to remember what the like what I was thinking when I was driving, what else was around me. Some of the scenery might have even changed. And so you need statutes of limitations that are appropriate to the kinds of harms that have been experienced. But you also need them to be appropriate to the kinds of other mechanisms and relationships that you're trying to encourage. Thanks, Alina.
Thanks, Tara. Over to you, Anirudh. Participants requesting you to please keep your questions coming, and we'll take them after Anirudh's presentation. Thank you.
Great, thank you. Can I still be seen and all of that? I know that I can't.
We can see you. We can see you.
Perfect. Maybe before I launch into to this, I actually wanted to pick up on, I think, Soumya's question, because I think the two of the sort of angles to your question are actually very interestingly brought out, I think, in this presentation that I'm about to give. So I just wanted to make this a bit more interactive and flag that in this presentation, I think it will be interesting to see how a parent company, in my mind, and I think in the communities that we support, in their minds as well, just how important a parent company is to fixing social issues that are really structural. And this is an example I'm about to present of a parent company that has kept a subsidiary undercapitalized and without enough expertise or resources to really fix the serious issues that need to be sorted out. So I thought that was a really interesting question that you asked from that angle. And also another part of your question was around what is the role of employees. Again, this is an interesting case study that I'm going to present because it involves a worker shareholder company. So that shared sort of ownership model where you try to have workers be part of the decision making of a company. And so yeah, it's another sort of interesting wrinkle to your question, because in this particular example, maybe there are some responsibilities that workers have as part shareholders in this company, but as we'll see, they have to be given the ability to assert their rights as shareholders. So I just wanted to flag that as a teaser for what's about to come, but I thought it was worth mentioning. In terms of who I am, my name is ANIRUDHA. I am the Communities Director at Accountability Council, and we support communities that are harmed by internationally financed projects. We specifically support them to navigate these often technical, unknown, complex at times, non-judicial mechanisms. And specifically, we're talking about non-judicial mechanisms that are tied to internationally financed projects. So there's a whole bunch, there's some 20 odd accountability mechanisms that are tied to international finance institutions and development finance institutions like the World Bank. Then there are a whole bunch of accountability offices that are tied to the OECD guidelines on multinational enterprises. They're called national contact points. But today I'm focusing on a case study that concerns the former category of accountability office tied to this international finance institution. So maybe I can say a little bit more about myself just so that it's a little bit more human. And I wish that we were all together. Mind you, it feels very strange to do this without anyone in front of me in my bedroom here. I am an Australian trained lawyer, but I've for the last 7 years lived in New Delhi in India. I currently am in Melbourne, Australia, so it's a bit darker than it probably is in India at the moment. And I'm just assuming that the great majority of folks on this webinar are from India, but I understand that that's not the case for every single person, so forgive me. And so yeah, it was in March of this year that COVID-19 and all of the disaster that we've seen that has brought sort of forced me to make the difficult decision to come back to Melbourne and be closer to my family that lives here. So I hope that everyone is in good health and is doing okay. I know that things are not great in Delhi, so just sending my thoughts to everyone out there. So maybe I can. How do I change this slide? Hopefully that is working. So I wanted today to focus on this sort of unique, I think, but very interesting case that I've had the pleasure of working on for the last 5.5 years. It concerns a company called Amalgamated Plantations Private Limited, as you can see on the slide there. It's majority owned by the Tata Group through 2 Tata Group companies, Tata Investment Corporation and Tata Global Beverages Limited, which is now called Tata Consumer Products Limited. They had a restructure a couple of months ago. So it's majority owned by the Tata Group, 65%, and its second largest shareholder is the International Finance Corporation. That's the private sector side of the World Bank Group. And then you have, because it's this worker shareholder company, you have 9% of the shares that are owned by workers. These are ordinary shares that workers own. So I wanted to kind of first, present the picture of this company and then sort of go into, where this fits in terms of Accountability Council and our advocacy. So Accountability Council, as I said, we support communities with locally led strategies. And we're going to get to a poll question in a second, but there are a whole bunch of strategies that local communities and civil society organizations are engaged on, all sorts with respect to fighting against business and human rights violations. You can see some of them that I've mentioned on the slide there, including ground resistance or protest, domestic legal and administrative options, such as, or maybe quasi-judicial, if you want to call the National Human Rights Commission in India, media coverage, network and alliance building. There's direct engagement with shareholders, project implementers, funders, and then where Accountability Council kind of fits into this picture is the final bullet point there, which is complaint offices that are tied to international finance. And as I said earlier, these are non-judicial grievance mechanisms. They're not courts. They're not binding, strictly in a legal sense. They really rely upon good faith and persuasion, and for institutions to do the right thing and listen to their accountability officers. And we'll see some of the challenges around non-judicial mechanisms in this case. So before we kind of go on and launch into what exactly life is like for tea workers, and that is what we're talking about here, Amalgamated Plantations Private Limited is either the largest or the second largest tea producer in India. It has 25 plantations across the state of Assam, some 21 plantations in Assam, and 4 plantations in West Bengal. So it really has, I think, a really large capture of the tea industry in the Northeast, if not across India. So before we go ahead and I continue on that thought, let's maybe have that poll question, Elena, if you don't mind.
Sure, Anirudh, I'm just launching the question for you.
Sure. I think this was the same question that actually you all had to fill out, or some derivative of it, when you registered for this webinar. So sorry for the repetition, but I'm really curious to know, your answer to which of these is the most accessible in addressing business and human rights violations in India or South Asia. And the options are courts, national human rights institutions, UN mechanisms, or international finance accountability mechanisms, which I know that many of you may not have heard of until 5 minutes ago. And there's no right or wrong answer here. It's not a trick question. It's really, I'm just really curious to know what people think is, the most accessible or even the most effective, although the answer might be very different actually if the word were effective and not accessible.
I hope you see
Great.
the results.
I do. 30% courts, 54% NHRIs, 5% UN mechanisms, and 11% international finance accountability mechanisms. That's really interesting that 54% of you have that view about the national human rights institutions. Great. I'll try to unpack that and come back to that as we work through the case that I want to present. But great. So I wanted to sort of start this case study by just getting very real and explaining, an average day in the life of a tea worker at an APPL plantation. I'm going to use that acronym for Amalgamated Plantations Private Limited. And so, typically a tea worker might wake up in the morning at, 5 a.m. really early. If they're a tea plucker, the majority of which are women, then they will often have to prepare food, get their children ready for school or for creche. They will often be required to attend work by 7 a.m. or 8 a.m. They will then spend, hours plucking tea. Sort of, it's very back-breaking work in the harsh sun for 6 days a week. They only get one rest day, and some work overtime. So for some workers, it's 7 days a week. Tea pluckers have to pick 24 kilograms a day if they're to earn their full wage. If they don't earn that, if they don't pick that full quota of 24 kilograms of tea leaf, then they can face wage penalties. And particularly in the peak season, so in the months of June, July, August, that wage penalty will be enforced because there is an abundance of tea leaf and they're expected to meet that quota quite strictly. Pesticide sprays, if you're a pesticide sprayer, which typically is performed by men, in fact, I think exclusively is performed by men. So you're already seeing that there's a gender differentiated type of work duty and therefore different impacts that we can maybe unpack if there's questions about that. But if you're a sprayer, then you'll be required to spray, unfortunately, a lot of the time without full access to proper protective equipment, so the full mask and the gloves and the goggles, or if you do have access to that, if you're one of the lucky ones, that becomes very hot and sweaty in Assam's very humid, harsh climate for many parts of many months of the year. And so you're often exposed to hazardous pesticides and chemicals because you often don't have the ability to wear equipment, or it's ill-fitting and ill-suited to the climate. At the end of the day, workers will come home to really dilapidated housing, to broken toilets, and that is if they have toilets, to dirty drinking water, to inadequate healthcare. They'll often have to defecate openly if they don't have a functioning toilet. That will result in disease that is exacerbated, that will result in malnutrition. Assam really unfortunately has one of the highest maternal mortality rates in the world. It also has very high incidences of, and this is specifically in terms of tea plantation workers in that population, studies have shown that this population is very susceptible to tuberculosis and to other infectious diseases. Anemia amongst women and girls is very high. So conditions and human health indicators for tea workers is really, really poor. And so they do all of this for 164 rupees per day. So not nearly enough to live a life of dignity, and not nearly enough to be able to provide, if you have children, dependents, with the basic 3 consumption units that you need to survive. And so tea workers in Assam face this constant daily struggle to survive. And it actually is one of the sort of root causes for the generational servitude that has existed in Assam for tea workers. There is, of course, a colonial legacy here. The British brought Adivasis from central India to the northeast of India, particularly Assam, to work on the tea plantations. But more than 150 years has passed, and the conditions remain really grim. And so it's really quite common for you to hear of people who are born on the plantations to live their life on the plantations and to die on the plantations. And that sort of happens generation after generation. There's unfortunately no real alternative livelihood option for many tea workers, and educational opportunities are really difficult and really poor quality, that many tea workers, don't have the ability to lift themselves up from this situation. And so that's where sort of the idea from the Tata Group and the International Finance Corporation came along to create this worker shareholder company. Tata had successfully, well, they describe it as having successfully done this in the south of India, in Kerala and Munnar, and in terms of setting up this company that was sort of run in part by workers by giving them shares in the company. So they thought, let's try to do this with the IFC, the International Finance Corporation's help in Assam and the Northeast. Unfortunately, the context is very different in terms of literacy, and unionization is very different in the Assam tea sector. There's just one union that is recognized by the tea industry, the Assam Cha Mazdoor Sangh, and Kerala has a much more open, unionized labor force. And so for a bunch of contextual reasons, this hasn't worked in Assam, and the company is unfortunately not in good shape, and workers continue to experience a really hard time. One thing before I move on to describing the complaint process to the International Finance Corporation, I wanted to just mention that tea workers are basically under this system of dependence, where they depend on their employer for almost every facet of their lives, which is also one of the root causes for why they haven't been able to lift themselves out of the situation, or that very few are able to do so. And just to understand this, it's important to understand that they depend on their employer for housing, for drinking water, for schooling, for creche, to look after their children. Almost every facet for healthcare as well. Almost every facet of their lives requires that the company, under the Plantations Labor Act, which has instituted and perpetuated this very kind of captive population plantation model. That means that if they lose their job, they lose their house, they lose their healthcare, they lose their everything. And so if you can understand that, it really is important to realizing just how vulnerable these communities are. And the second aspect that is very important to understand is just their identity as Adivasis. They don't have natural allies in Assam. Unfortunately, they're often considered to be outsiders. And so even though in West Bengal, the Adivasis have been given ST status, scheduled tribe status, so they have the ability to at least have access to quotas for education, employment, etc. In Assam, they haven't been granted ST status, and so they sort of are facing multiple levels of marginalization, not just being physically and geographically remote and separated and dependent on employers in this captive way, but also in terms of their identity as Adivasis. So in 2013, two local Adivasi organizations called PAJRA and PAD, you can see the full forms on the slide, they filed a complaint to the IFC's Accountability Office called the CAO, the Compliance Advisor Ombudsman. And in their complaint, they talked about all of the issues that I've sort of outlined with respect to poor living and working conditions. In 2013, soon after filing the complaint, there was an attempt at dialogue. Unfortunately, that dialogue wasn't very successful. It broke down when the parties couldn't agree to some basic ground rules for sitting at the table and trying to work out the issues. And this dialogue table consisted of the complainants, so we're talking about PAJRA and PAD, who support and represent tea workers on the one side, and then on the other side, APPL, Amalgamated Plantations Private Limited, the company. And they were, unfortunately, as I say, not able to reach agreement on some basic issues and the dialogue broke down. In 2015, after much delay, the Compliance Advisor Ombudsman, this accountability office, was able to enter India and conduct a site visit. And you'll see a photo there of a site visit where it was quite remarkable being there, seeing tea workers being able to speak directly to an accountability office and say, in their own words, what their issues were with APPL and what they wanted from the IFC. I should say that the IFC has these performance standards that basically are social and environmental rules that govern financing, that require that any borrower or recipient of IFC money, these recipients are required to follow these standards. And so this particular case, the crucial standards relate to Performance Standard 2 on labor issues and Performance Standard 7 on Indigenous peoples. So again, we can go into those if people have questions, but I just want to quickly get through the rest of the story. So in 2016, the investigation report was released by the Compliance Advisor Ombudsman, the Accountability Office. And you'll see there that it really vindicated almost every aspect of the complaints that were filed by Padra and Pad, including low wages, restricted freedom of association, hazardous housing, toilet, sanitation, drinking water, exposure to dangerous pesticides, and poor consultation with workers across the board, but also with respect to the shareholder program. On that last point, it was basically found that workers had complained that they had been basically forced to buy shares. Many of them described that there appeared to be quotas that IFC or APPL had come up with and were hell-bent on giving these shares to workers and saying, here's a private sector solution to a problem, and we're going to make this work whether you like it or not. The majority of tea workers don't understand what a share is. It obviously requires significant amounts of financial literacy, training, and support to bring a worker to a certain point where they understand, look, this is what a share involves. This is what rights you get as an ordinary shareholder. You can hold the board of directors accountable. It requires that you allow workers to attend the annual general meeting to be able to vote. It requires quite a lot, and instead workers were told, you're going to double your money, you're going to make all of this money, subscribe to this share program, and your life will be better for it. The rationale of the shareholder program was, as I said earlier, was that if you give workers a say in a company and the ability to make decisions in the functioning of the company, in theory, you can sort of give them the agency to lift themselves out of poverty by having that agency in decision making. I think it's an okay idea in theory, but it was very poorly implemented in this case in practice. So after that really strong report from the Compliance Advisor Ombudsman, and I realized that I'm sort of needing to go a bit quicker. Elena, can you please give me a time check? How much longer do I have?
We have around 16 minutes to go, but I think we started 5 minutes late, so I think 20 in all. Okay, so I'll sort of wrap up as quickly as I can so we can have some time for questions. Sure. When I say last mile, that refers to the fact that there was this really strong report from the Compliance Advisor Ombudsman. It was 94 pages long, the most comprehensive report that they've ever done, vindicated almost every complaint from the workers. However, the IFC's response was 3 pages long with an annex. And the IFC said in response, basically, we largely disagree with the CAO's report. And they said that they disagreed on really most of the issues, and the only thing they really agreed with was issues around housing and sanitation, toilets, and drinking water, that those issues affecting human health, they did acknowledge were a problem,
and they came up with this 2-year action plan that they said that they would work on for 2 years in an accelerated way to address these issues. Unfortunately, 2 years passed and they really didn't do, they did very little to implement that action plan. And together with the complainants, we did a lot of press and documentation and petitions. There's in that top right corner, you can see a petition where we gathered some, almost 70,000 signatures to send to the IFC to say you need to do more. We documented preventable deaths that were happening in 2018. It was covered in the Indian Express, across Indian media, the Hindu as well, and we were able to really document all of the problems that persisted even despite this independent documentation by the IFC's own accountability office. In 2019, the CAO did a follow-up report. They did a monitoring report, and they confirmed that in the preceding 3 or so years, the IFC had made not enough progress, that there had been bits and pieces of progress here and there. Some toilets had been built, some houses had been built, but even on the narrow issues that the IFC agreed with, and even on their own promises that they said, for example, that they would ensure that every household across APPL plantations had access to a working toilet. That was clearly not met and continues to not be met. And it was very damning, actually, in this report, where what became very clear was that APPL told the CAO that very early on in the action plan that we do not have the money to fully implement this action plan. We have posted losses for, I think, 4 years running now. This is a company that doesn't have, or claims not to have, any money. Meanwhile, the Tata Group, does have significant resources. The IFC does have significant resources. So the two largest shareholders of this company has significant resources. So it goes back to Soumya's question around what is the responsibility of parent companies. However, in this case, we've seen that the IFC and the Tata Group have to date not provided APPL with the resources, the expertise that it needs to be able to address these really long-standing, very widespread violations of the IFC's performance standards. And so it was really disappointing when the IFC responded to this monitoring report, and it didn't respond substantively to any of the non-compliance findings. And this time it said, okay, we're going to do a sector-wide study and a facilitated dialogue. So we're hoping really very soon that that dialogue can get off the ground, and that Tata will come to the table, that the IFC will come to the table, and that after all of these years we will come full circle and attempt a dialogue again, and that this time hopefully we can find solutions that to these long-standing problems. So let me just wrap up with a couple of slides in saying that these accountability officers that are very they're a work in progress. As you can see, this story is not one of full-blown success. There's been some tangible improvements for workers, but in many respects they're still waiting for this strong report from the CAO, or series of reports, to be translated into practice. And so I just wanted to end with 2 slides, one that describes some of the challenges of these non-judicial mechanisms. And if I just run through them, mechanisms are not courts, they need teeth to be effective, and that's where I think civil society plays a big role in doing that, press advocacy and resource sort of network building to give these mechanisms some teeth. It also takes significant time, resources, and there's documentation and evidence that you need to provide to these accountability officers to be able to document that their safeguards have been violated. And you'll see that we've been doing this case now for 7 years, so they're also very long in terms of just how much fatigue that can bring to a community. There's potential for failed negotiation. So negotiation or dispute resolution processes are voluntary, and so at any point either party can walk away. So that's something that can be quite challenging. There's potential for loss of opportunities to address an issue or momentum in a movement if you, for example, over rely on the IFC accountability mechanism and you don't think about what can you be doing on the ground in India, in Assam? What can you go to the NHRC? And in this case, communities have tried to go to the NHRC. Can you go to the Guwahati High Court? Can you protest? I think at the very start of this presentation, I showed a picture of maybe if I can go back there of a protest where you'll see there. Some of you may know Tata Tea's Jago Re cause marketing campaign. They had this marketing campaign about I think 2 years ago. It was something like "Be proactive, alarm bajne se pehle jago re." So the sort of folks on the ground were saying, Tata, you need to wake up yourself. Jagane se pehle khud jago re. Wake up yourself before you tell everyone else to wake up. So there's other viable strategies that you should be thinking about. And in my experience, actually, these mechanisms are most effective when you combine them with some of the other strategies. And so on my last slide, here's some of the potential benefits of accountability mechanisms. That you can raise the profile to an international level of these issues, media attention, and you can, I think one of the most compelling for me as a former sort of lawyer in the judicial sense, you can really allow for communities to have agency, whether it be sitting across the table in a dialogue or speaking during a compliance visit. It allows tea workers to speak directly, quite literally, to funders and in this case the IFC and to Tata, and to say this is our concern and this is what we want you to do about it. So thanks very much for hearing me out, and sorry that I've gone over and not left much time for questions, but hopefully we can spend some time now for any questions that people have.
Thank you, Anirudh. I see Tara is also back. So I'm not sure if you guys are able to look at the series of the numerous questions.
Yeah.
So one of them, yes. You want to start?
Well, actually, I have a few for Anirudh because I know how hard it is to sort of scroll through those quickly. So I'm going to give you your questions and then I'll answer a few that are for me so that you have time to think about what you want to say. Is that okay?
Please.
Okay.
Thank you.
So one of the questions from, and I'm really sorry, I'm about to butcher a lot of names here. So Joy is, do tea workers or any other workers realize that their injustice relates to human rights? And then there's a question, I'm sorry, I forgot who actually asked this question. But it was at the very bottom. So Tarun, I think, what other organizations like Accountability Council are doing this kind of work in India, and how are organizations like yours funded? And then there's a combination of questions. So Niraj and Soumya were asking about state-run companies, and Akiko about ODA, so Overseas Development Assistance, and public-private partnerships. So what's the distribution of responsibilities? What are the options for informal workers? And then within that, there was also a question as to whether or not tea workers are part of the unorganized sector or informal workers. So I'm going to leave those for you to answer. And I'm going to take a few other ones. So Marine Joy J also asked or pointed out that mere monetary compensation can dehumanize situations and victims, and asked whether or not there are binding treaties that address this. There aren't treaties that specify reparations or what they're supposed to look like. That actually comes from general principles of law, and that's one of the primary sources of international law according to the ICJ statute. And so we have case law going back to 1928 recognizing that reparations and this obligation to provide remedies is a general obligation that always attaches whenever there's been a wrong in law. Cedric pointed out that businesses are not only economic actors and that there is an ongoing debate about this. That's absolutely true. There are alternative models. So we have B Corps now. There's also discussion within company law generally about corporate social responsibility and how do they function as corporate actors. That said, we still see corporations often default to being primarily economic actors. When they're surveying all the different options that are available to them, they often default as to what's going to be the most profitable for the shareholder. And you saw that a little bit in Anirudh's, in his example, where businesses were willing to operate in ways where they just couldn't operate sustainably. They couldn't provide reparations and action plans appropriately, based off of how they distributed resources. These companies were inevitably paying the shareholders and the parent companies, and the parent companies were underfunding the subsidiaries for the purpose of avoiding some of that responsibility. And so while there are alternative models, they're not particularly widespread. And then Sheila pointed out, and thank you for pointing this out in the comments, Sheila, that OHCHR has an access to remedy project ongoing, and they've recognized explicitly within that, within section 8.4 is what she said, that victims can't be required to waive access to other remedies. They might, and I completely agree with that, they can't be required to do so. In my answer before, what I was trying to say is there are times in which they can voluntarily agree amongst themselves with the other party, and this will be rare. It's going to be in particularly sensitive issues where the victim feels that it's actually in their own best interest, and then we need a control mechanism to make sure that they're actually freely consenting, and that should involve some sort of judicial oversight of those kinds of agreements. And then the final thing is, Akiko asked, it's hard to have a perfect remedy, but it's important that victims feel heard, and how can you evaluate that? The answer is actually really simple. Ask the victims afterwards, right? Like, have an ongoing dialogue and have a mechanism that can evaluate afterwards how victims felt they were heard in the mechanism. And that should be part of this ongoing continuous learning for both judicial and non-judicial grievance mechanisms. If you ask people, how did you experience this? What did you do? At the end of this, you'll get a poll about how Anirudh and I did today. Same kinds of things can happen with judicial and non-judicial mechanisms. You can ask people what they felt like afterwards, and that's my suggestion for that. So Anirudh, I'm going to hand it over to you for your questions.
Thank you. I know that it looks like we have 3 minutes, so I'm going to go in rapid fire fashion. Okay, so I think Tarun asked, are there other organizations doing this type of work in India and how are they funded? So just to be clear, there's these organizations, there's one called Center for Financial Accountability. There's a few others, but that is sort of one of the best known organizations. It supports community to navigate these complex processes. And you may know actually of, and you may have heard of a tie-up between, again, it has so many analogies to this case, the IFC and the Tata Group on the other side of India in Gujarat, Tata Mundra. There was a case that sort of is quite high profile because the fish workers went, fishing communities rather, went all the way up to the US Supreme Court, and Center for Financial Accountability was certainly involved there. These organizations have sort of different sorts of funding. I can speak to accountability councils. We are a US-based organization, so our funders are, and we're based in San Francisco. That's where our founder happens to be from. And so a lot of our funding comes from philanthropic foundations. So you may have heard of Open Society Foundation or other 11th Hour Project. There's sort of family foundations or larger philanthropic foundations. We have quite a strict conflict of interest at Accountability Council policy, where we don't want to accept money that is going to taint us and our ability to do community-led work. So we don't take money that is, from corporations or that sort of thing, or even from governments, because some of our other work involves, communities that are, pitted against, in some ways, government actors. So hopefully that answers your question, Tarun. Another question, I think, was, are tea workers considered informal or formal? The short answer is that the tea workers that are part of these large companies in Assam, for example, like the Tata, the APPL example, they're considered formal workers, because they have contracts, they're on the books, they get, rights to certain rights that are not always, implemented, enforced, but they're considered formal, part of the formal economy. There are tea workers that are part of small tea growers in Assam that are considered informal workers, and there's fewer laws, if any, that really apply to some in those situations. I'm struggling to remember. Oh, there's another question, that's right, on what about overseas development assistance or public-private partnerships? I think that was a question by, was it Akiko? Yeah, Akiko, that question. So from our perspective and the ability to access a non-judicial mechanism, we really rely on the fact that there's going to be, either a government behind that overseas development assistance that has, say, for example, a national contact point that you can go to that's set up under the OECD guidelines, or in that sort of public-private partnership structure, if there is, either an OECD country and therefore you can trigger one of those national contact points, or if there is some other bilateral financier that has an accountability office, that's what we rely upon. So this strange universe that I've just spoken about does rely upon that initial question of, is there an accountability office tied to the international finance? If that's not ticked, then you have to rely upon other sort of advocacy options, and then you look at the other options that we spoke about at the start of that presentation. So it is a bit arbitrary in that sense about access to remedy, and really this is a work in progress. I think this whole system of accountability that's non-judicial is a work in progress. We have a policy team as well, and part of what they're doing is trying to work on creating accountability mechanisms where they don't exist. So a big part of that work, for example, is working on trying to create accountability offices tied to Chinese finance, particularly when Chinese finance is going abroad, which at the moment we get lots of communities coming to us. We have cases in Nepal and in Myanmar and in Mongolia. And in those parts of the world, I'll get people continually saying, thanks for, doing a presentation like this, but what can we do about this Chinese-backed project? And at the moment, we don't have a lot, unfortunately, to answer. There are some really strong, safeguards and policy instruments coming out of China, but at the moment, there's not a great deal in terms of enforcement for, communities to drive, a complaint process. So I hope that answered. And if I can take another 30 seconds and just say, I really loved the comment from, I think it was Mritunjay. Sorry. He said that, or the comment was something around the fact that in Assam, these tea workers are often described as part of the tea tribes. And our partners in Assam really dislike that framing because it's very fatalistic, and it suggests that these people have, that they're people to begin with, and that they have no other fate than to just work on tea forever. There's not some other hopes and dreams that they have to live life with dignity that all of us have in our lives. So I really appreciated that comment, Ritunjay. Thank you. I really reject that label and think it's really unfair.
Thank you. Am I audible?
Yes.
Thank you, Anirudh. Before, I think we could take, if you guys could quickly, share your thoughts on the FDIs and how, because I saw one of the questions that Soumya had raised earlier, because of course we see that a lot of policies, government policies and moves are now directed towards, ease of doing businesses, declaring SEZs and without any checks and balances. So a lot of, and I also saw this 100% FDI into coal coming into India. So do you guys see this as, they are doing no required due diligence in terms of before coming into these sectors, which leads to human rights violations at various levels?
Yeah, I think that that's a really accurate portrayal of a situation. It's not that no companies do it, but that it's really unusual for due diligence to be a part of a routine process. And we find that it's a very small number of companies. There's an organization called the Corporate Human Rights Benchmark, and they actually evaluate the public reports by companies to say whether or not they're complying, whether or not, at least on paper, they're complying with the UN guiding principles. So how are they describing their human rights due diligence processes and policies and remediation processes? And I think last year the highest scoring company was only in the 80s. Like out of 100%, they only hit about 80%. And the vast majority of companies were far below that. I think there were only 2 companies out of 200 that actually hit the 80% mark. And that tells you how far it is that we still have to go. So yeah, I think multinational corporations they should be the biggest leaders in this. They first of all are the ones that have been the largest part of the problem, and not just now, but we've been dealing with what transnational corporations and foreign direct investment, what the responsibilities should be there for 40 years, explicitly at the United Nations. We've been dealing with it for several hundred years when you think about the history of colonialism and slavery, right? So we know that transnational corporations were intimately involved in colonialist enterprises that led to widespread and massive human rights violations that we're still grappling with today and that we still haven't remedied appropriately. And they were involved in the transatlantic slave trade and in other areas of slavery. Again, widespread systematic human rights violations that we still haven't grappled with. And so we have known for long enough, and they have known long enough about the risks that they pose, that this idea that they've only had since 2011 when the guiding principles came out to grapple with their history, and they still need a little bit of time to learn and they're trying their best. I can't accept that. I can't accept that because this isn't a conversation that we started in 2011. 2011 was a turning point, but it wasn't the start of the conversation. The conversation's been going on for hundreds of years and explicitly at the United Nations since the 1970s. And I can't accept it because they know what they're doing. Somebody in the comments, I forget who said this, somebody pointed out that oftentimes there's a calculation about the remedies that are paid. So businesses continue to operate in a particular way because it costs less to do so. And having to provide actual remedies, having to provide appropriate conditions for tea workers in Assam would cost too much money, and it makes it less profitable, meaning it makes it less desirable for the elites within the society to pursue. That's why they make the decisions that they do, and that's why they're not engaged in due diligence. And that's something that we fundamentally need to shift company law and business law and all other forms of regulation to make sure that they're forced to take on human rights due diligence and that they're forced to develop and respond to appropriate remedies and reparations. Anirudh?
I don't know if I can follow that amazing answer. The only thing I will add maybe is that there's an example of, in this case that I just presented, of really poor due diligence by the International Finance Corporation. So before it invested in this company, in the Tata Group and in the formation of APPL, it was supposed to do really rigorous due diligence to ensure that public money, which is what the IFC is using, goes to achieve its mandate. The IFC's mandate is to reduce poverty. And so unfortunately, and you can see this in the CEO's report, sort of documented in great detail, the CEO describes that the IFC over-relied on Tata's reputation. So it over-relied on, the fact that Tata has this code of conduct and this, prized reputation for ethical business. And it also over-relied on certification. The fact that APPL had signed up to this thing called the Ethical Tea Partnership, the fact that APPL had signed up to ISO 8000, this other certification system. These are promises of compliance, not evidence of compliance. Yet the IFC looked at these things, did really a poor job of understanding just how much risk this investment had in terms of environmental and social standards, particularly social standards, and went ahead and invested. And they've almost they don't make any denial about that, because they really underestimated the level of destitution and what it would take to address these deep-seated social issues. And I realized that a lot of the time people ask, why Tata? Why are these tea workers bothering Tata? There's a bunch of tea companies in Assam, and the answer to that is that when you have two global powers so-called global powers in sustainability, that's a formidable partnership. And if anyone else can do it, it's Tata and the IFC. And so the idea of this investment was to initiate change in the broader industry. The idea being that if they could do it and show to the rest of the industry that here's how you can make change, then you can trigger change for the others. So yeah, I just wanted to add that wrinkle that there's really poor examples of due diligence out there because of some of these other factors that come in that almost act as shields to seeing the true state of a plantation. A certification system can act as a shield. You have to really go out to the plantations, meet with workers in a way that they can speak freely. It would take a lot more in terms of resources and goodwill for due diligence to happen in the way that it should.
I don't want to take anything away from that amazing answer. Like I was sitting here nodding along because I completely agree. But I do want to make clear to people that certification schemes are not designed to assess whether or not a business complies. They're designed to assess whether or not a business, they're designed to encourage thoughtfulness about how you act as a company. They aren't designed to evaluate that at the end. Most certification schemes simply don't have enough auditors or enough people involved to know whether or not a company actually meets the promises that it said. And so this issue of relying on certification schemes as due diligence, there's so many studies, and an increasing amount of literature showing that these schemes are actually schemes in the negative sense of that word, right? They're actually manipulating in many ways companies, international organizations, states, and fundamentally the consumers by suggesting that companies are doing things that they're simply not. And the schemes are just not, certification schemes are not designed to actually achieve results. They're designed to encourage thought. So Alina, I think.
Thank you both. I see that we have covered most of the questions, and participants have actually very well received the presentation, and they are asking for the slides. So I would just inform that we'll be sharing all the slides with you very soon, and the recordings will also be available on our website. So please, requesting you to stand by for the materials to be circulated. Thank you so much everyone for joining for today's webinar. I hope it was useful for you, and I hope to see you tomorrow, which is the last day of the BHR course 2020. Thank you, presenters, for once again for sharing your thoughts on the issue. Thanks. Bye-bye.
Thanks, ANIRUDHA. Like, that was amazing.
Thanks, Tara, and thanks, everyone. Bye.
Bye.